Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have with us one of my partners from Duffee+Eitzen, Jodi Bender. She heads up our Wichita Falls office. Welcome, Jodi.
Thank you for having me today.
Oh, we're so glad you're here. So you had something very exciting happen this year. You got to argue in front of the Supreme Court of Texas.
I did. It was really a highlight for me and my career, and it was, I would say it's a lot of fun. It was a lot of fun for me looking back.
It was probably very stressful.
It was a lot of work and a lot of preparation, but we prevailed. We were successful in our arguments, and so
winning is fun.
Winning is fun.
So for the non-lawyers watching, why is it a rare occurrence to get to do that?
So our court system has in Texas has 3 tiers, and you have to think about it as most people, they're going to be in court at the trial level, and that's the district courts and our county courts. Those courts are where you go to trial. That's what you would think of when you see the trial on TV, when you see trial court. Whether that's criminal or civil, you're in front of a trial judge, you're putting on evidence, you're calling witnesses. And it's only if there's an error at the trial level that is identifiable, whether there wasn't evidence to support a ruling or there was some error, that it could go up on appeal. Now,
it's not just a do-over.
It isn't a do-over.
You say, I want to appeal. It's not because I lost and I want another chance.
No. In fact, in family cases, the trial courts have so much discretion in so many areas that it's very rare that you can appeal. Your first level of appeal would go to an appellate court. A second, if you think about it as a tier, the trial court's here in the appellate court. And the appellate court has jurisdiction to review. I mean, of course, you have to present what the error was, and on certain things, they have jurisdiction to hear those appeals. You don't have to ask for their permission. But if you think the appellate court, after you get your ruling from them, if you think they were still wrong, you can ask the Texas Supreme Court to hear your case, but it's not automatic. The Texas Supreme Court is very selective about the cases that they hear. Probably only, I've not looked at recent statistics, but it's less than 10% of the cases that they are asked to hear, they will choose to hear. So it's only cases that are going to affect the law in Texas or have there's an important reason the Supreme Court feels like for Texas law that they need to hear a case.
So, for example, we have more than one court of appeals, right?
We do.
So we have the 5th District Court of Appeals, the 1st District Court of Appeals, so on and so on. And they could, on one point of law, have different rulings.
Yeah.
So this Court of Appeals could have said, no, we think it means this. And then somebody else in another Court of Appeals says this. That might be a reason the Supreme Court takes it, to clear up that, and maybe not, but it could be they want to clear up that disagreement between the courts of appeal.
Sure. Or they might say, gosh, this statute, we just keep seeing it over and over, and we don't think the courts are applying it the way that we interpret the legislature to have written it, or the intent behind the law. And we keep seeing these rulings, and all these different courts keep coming to us. I mean, all these people keep saying, oh, please look at this because it's not being applied right.
I see.
So there's different reasons that the Texas Supreme Court might take on a case. When you get something that's interesting is a lot of people don't realize when you get to an appellate level, you're stuck with whatever your record was at the trial court. So you're not putting on new evidence.
It's not a do-over.
Not a do-over. You don't get to call more witnesses or change what you presented at the trial court. You have to...
Better do it right at the trial court.
That's right. That's right. It is important to do it right the first time because you don't get a do-over.
And that's one thing. We're lucky to have you on our firm doing appellate work. You do trial work also. But when you have the lens of appeal, when you think like an appellate lawyer, I think you help everyone in the firm who's doing trial work to say, hey, make sure XYZ is happening. Protect your record.
Sure. And if you end up in trial, there's a lot of times that you might want to consider in your case bringing an appellate lawyer to trial with you, just to make sure that if there's a ruling from the court, you're preserving what we call preserving that error so that it could be taken up to the appellate court. So sometimes just having an appellate lawyer sitting there at trial is helpful to the trial attorney. So there are times that I get hired just to come on to the case to look over everything. Are all the I's dotted and T's crossed? And will you come to trial and just listen and make sure we've made a record of what we are trying to prove? Just having an extra eye on it with that appellate issues in mind.
One thing you talked about before is error, that the reason you could maybe have an appeal is if there was an error. And often the error is the judge did not let evidence in that the judge should have let in, or excluded evidence that shouldn't have been excluded, right? So one way or other, the evidence would be a common error. And when you're live in trial, you have to make sure you're making the right objections at the right time to whatever the judge is doing in order for that error to be preserved.
Correct. And one thing I think, that trial lawyers also have to keep in mind is an appellate court might look and say, yes, that was an error, but was it harmful to the case?
Right.
And so if the record doesn't show
how
it would be harmful, you've still waived it. So they might say, yeah, that was a mistake that didn't come, that evidence you had, that really good piece of medical, that witness that was going to say exactly what you needed them to say, that the judge didn't let them talk. So there's ways as a trial lawyer, you have to go in then and say, okay, judge, I know you didn't let that in, but I need to still make a record and put the evidence on so that the appellate court knows, even if the objection was, okay, the court finds the objection was wrong and it should have come in, you still have to show why it caused harm to not have it in.
Yeah. So it's kind of strange sounding, but you have to say, judge, let me tell you what they would have said had you let them testify.
Yes.
And there's a formal way to do that. But some trial lawyers don't. They don't take that extra step. They're in a hurry. They're worried about their time management. They just accept the ruling and go on. But if that case is one that's likely to go on appeal, either way, whoever loses might want to appeal. You have to be more cautious.
Sure. And that's where having your appellate lawyer poking at you, saying, oh, do you offer proof? Do you offer proof? Or make sure you get a ruling on that. Just somebody that, because being in trial is, it just kind of takes over. And, your lawyer should be very prepared, but you're still having to adjust as you go through trial. Yes. And you really are kind of in the middle of
there's a lot of things to think about.
Battle. And so having that third person that's not in the heat of the moment, that's just looking at it and saying,
the trial lawyer is thinking about, what am I doing next? What am I saying next? What's my next argument? Who's my next witness? The appellate lawyer can just be like, whoa, before you move on, we have to clean this up a little more. And that could be done live if they're sitting next to you.
Yes.
Okay, so back to your case. So you had a case that you asked the court, Supreme Court of Texas, hey, we think the appellate court messed up. We want to be heard. And they said yes.
They did. They did. That was really exciting. And the other kind of misconception is that an appeal can be quick.
Oh, it takes forever.
In our case, it was 2 years after the trial before we made it through a Court of Appeals level, and before the Supreme Court even asked us to write briefs for them to be able to look at the issue and decide whether they wanted to to hear it or not.
Mm-hmm.
We were several years out from trial before this happened. And then even we didn't get a ruling. It was almost 4 years to the date from the date of the divorce until we got our ruling from the Supreme Court.
So not for the weary. I mean, you have to really be willing to hang in there as a client,
Mhm.
right? This has to be worthy of pursuing. It's a reason for people to settle sometimes.
Yeah.
And they could settle even after trial before this whole appeal process.
They can. You can settle at any point in time in
Mm.
any of this. And we continued to engage in negotiations, but at some point too, once you've gotten to that point, everybody is pretty set
Invested.
in their argument. And
It's hard to settle.
it is kind of hard to settle it.
Okay, so explain to us, what was the issue that you brought up to the Supreme Court and won on, and how did it clarify, interpret, or change the law?
So there were several issues that my client did not fare well at trial. And we were the trial lawyers.
Mm-hmm.
We were stunned by the ruling. That's not an understatement. We were really surprised when you looked, and all of our issues were property division.
Mm-hmm.
So it was different assets that belonged to what we argued should have belonged to the community estate
Mm-hmm.
that were awarded to husband as his separate property. So we were saying the trial court erred in characterizing those assets.
Okay.
So we appealed on several issues. I think we had 5 different points on appeal to the Court of Appeals. 2 of them they ruled against us. And we really dropped those. We did not pursue those at the Supreme Court. There was one that was a big one. It was the marital residence.
Mm-hmm.
And we won at the Court of Appeals. In fact, we won so much so that the court said not only was that ruling wrong, but that it wasn't his separate property. It was actually half and half, both their separate property. Mm-hmm. And you don't even have to go back to the trial court to have them redecide that, how that gets split. Everybody, we're just going to say it's everybody. So our client got half of the house as her separate property. Okay. at the Court of Appeals level.
Okay.
So it was a house, it was a retirement account,
Mm-hmm.
and in the retirement account, we won at the Court of Appeals. The other side appealed that to the Texas Supreme Court, and because they took the appeal, they heard all these issues.
Okay.
So the retirement account, the house, and then the bonus. And the bonus was really where we appealed to the Texas Supreme Court. We lost on that issue at the Court of Appeals. They said, let me back up. Trial court said, hey, this bonus that he got, it was his separate property.
And this was a bonus at the date of trial that he had not received yet.
Correct.
But your argument was he had accrued it during the marriage. So for example, a lot of people, they get paid a bonus in the first quarter of the year for last year, right? So my performance last year, I get my bonus. And so if last year I was married most of the year, is that community, even though I haven't been paid it yet, or separate?
So that was the issue at our trial.
Mm-hmm.
This was a executive. Husband was an executive, and he was paid an annual bonus, but it was his performance during the prior year, and then it was approved and paid by February 15th of the following year. That had been the situation for 10 years.
Okay.
And the divorce happened in December of 2019. In February of 2020, he was paid the bonus.
For all of
his work that he had performed during 2019.
They were married the whole year, practically.
99% of the year they had been married. And our argument was, in Texas, community property, your compensation that you earn, the work you perform, is considered community property. So whether that compensation is in the form of retirement funds or stock options or a bonus or other forms of fringe benefits, that compensation that you receive for the work that you do, it belongs to the community. And so in this case, because that bonus, and it was a significant bonus that he made, was for work that he performed while they were still married. That was our argument all the way up to the Supreme Court, and they agreed.
And nobody was bickering about the paycheck he made in October, November, December, right? Those paychecks, everybody agreed that's community.
Yes.
And so, but his bonus was just after the actual date of divorce. So he was saying, that's income I got after the fact. But you were saying, no, but you earned it during the fact.
Yes.
Carry on.
Yeah. And, and I think for people that work in executive positions particularly, you have to look at their compensation packages, because it's not just their bonus. It's all kinds of deferred compensation.
Oh, right.
They may make $10 a month in their regular salary, and then at the end of the year get paid $5 million. And our argument to the Supreme Court was, Judge, that just leads people to gamesmanship.
Oh, right.
If you're in the middle of a divorce, can you just go to your employer and say,
Don't
you
pay
know what?
me.
Don't pay me anything. Don't pay me anything.
Give it to me next year.
Just wait, and after my divorce is final, then you can pay me all of my compensation.
And the higher up somebody is, the more likely they would have the control and ability to do that.
Yes, we believe so. And I mean, you need to look at things when you're getting divorced. Your property, you need to look at all of that compensation. I think everybody knows salary. We think about that. We don't necessarily think about, hey, those stock options that somebody is given that may not be exercised until 10 years down the road. But if they were awarded the right, or, awarded those options, the fact that they haven't been exercised yet shouldn't mean and doesn't mean, and that's what our Supreme Court confirmed as far as a bonus is concerned. You have to look at when the time period when that was earned, when that compensation was earned.
So when we say it's now found to be communities, both of them.
Yes.
Right. So it's not saying she gets all of his bonus. It's just saying he doesn't get all of his bonus. So who gets how much of the bonus?
Well, that's the situation we're in, is because the Supreme Court said, hey, trial court, you made an error in saying this was all his, and it wasn't considered in the pie that was divided between the parties during the divorce. If you think about it as a pie, it's all divided up, and most of the time, you know that there's other times, but most of the time it's going to be somewhere close to a 50-50 split. And if that piece of that pie wasn't included, you have a smaller pie to divide. So the situation we're in is the Supreme Court said, yeah, trial court, you should have included that and the bonus. I mean, the bonus and the retirement. There were some assets that you didn't include in that pie that should have been included. And so now you've got to go back to the trial court and do it again. So that the trial court...
So 4 years wasn't enough.
4 years wasn't enough. We've got to go back. But that's because those are fact issues of how that's divided. It's the trial court that hears the evidence and makes those decisions. The appellate court doesn't hear evidence. They don't resolve factual disputes. So
unfortunately, you won, but it's not over yet.
Not over yet.
So your client has to hang in there a little longer. So you all have to have a whole nother trial.
Yes.
But you could settle between, right?
We
could.
That's
still a possibility.
We could, and we're set for mediation, so we'll see how that works.
I think it has a higher chance of settlement because now everyone knows what's in the pot. There's no more fighting about that. The Supreme Court is the ultimate authority. But this ruling doesn't just affect your case. It affects the law in Texas for everyone because laws are developed two ways. Explain that.
So the law is developed in the legislature.
Mm-hmm.
The legislature is tasked with creating the law. We just had a legislative session. I know you've done other podcasts with attorneys talking about the changes to the law
Yes,
from the
yes.
legislative session. And so those changes, the legislature creates our laws.
Mm-hmm.
So we have statutes
Mm-hmm.
in Texas that tell us how the purview of the legislature is,
Mm-hmm.
retirement accounts should be divided this way. And in this case with deferred benefits, the legislature has created the family code that has rules about formulas for how we divide retirement accounts
Mm-hmm.
and how we divide stock options and things that aren't necessarily your salary compensation, like we were saying, as other forms of compensation.
Yes.
But the legislature has not ever directly addressed a bonus.
Okay.
Although they do tell courts, you have to consider bonuses, but they've never told us how to do that. So when we got to the Supreme Court, while they don't make law, we argued that because of the legislature's rules that they've made about how we divide all these other deferred
Mm-hmm.
compensation, you should apply that and decide that gets applied to a bonus as well, which is what they did. So they didn't really make a new law, but they applied it in a way that affects that form of deferred compensation.
So now, as lawyers, when we're trying to figure out, hey, what's the law? We're looking at two things. We're looking at the statutes, but we're also looking at what the Supreme Court and the Court of Appeals have said the interpretation of those laws are, or when there's kind of a gap in your situation, they're helping to fill the gap.
Yes.
Through the courts. So now what you did is going to affect law all over Texas. So that's exciting.
Yes, I was at the courthouse not too long ago and ran into another attorney, and he said, that case, you have that case. And he goes, I was just in mediation yesterday, and we were explaining, we were arguing about how this case applied to, because or how it applied to the bonus that was at issue in their case. Because the truth is, bonuses are structured all different ways.
Mm-hmm.
There's some cases out there that there's a kind of a famous case about a baseball player,
Mm-hmm.
and he was paid a signing bonus, but the signing bonus required him to be the pitcher for 6 years. And so they got divorced after year one. Well, what portion of that bonus was
Earned right
already
well,
at the
maybe
time they got
1/6.
divorced? Maybe 1/6. But bonuses can be structured in different ways, and it'll be interesting to see as we come across these cases, because I do think that there will be there's more cases that'll come out of the courts of appeals now that the Supreme Court has said you use this time allocation method to determine how this bonus is characterized.
Mm-hmm.
We'll see more cases that say, okay, but applying that to the facts,
right?
My bonus, the bonus of your husband's bonus was structured very different, and maybe that's where the arguments for lawyers to come in.
It'll be great though, because if you think about it, this isn't an isolated incident. I mean, so many people are on some type of bonus structure, and most people, some period of time, it could be the calendar year, that could be a fiscal year of that company, but there's some time of measurable time that bonus is associated with. So your case is going to affect many, many, many cases all over Texas. So you should be proud.
It will. It will, which is, and that's a good thing. I'm glad the Supreme Court did what they did, because really it will cut down in some of that gamesmanship.
Oh, yes.
But also the other rule, the rule the other side really wanted the court to say was, well, isn't it just easier to say it belongs to whoever went based on when it's paid?
And then people would try to stall, right? That would cause
People would try to stall.
someone in your circumstance to say, well, if the bonus gets paid in February, I'm not agreeing to a December trial date. I've got to have a reason to have a later. Just to your point, it just creates gamesmanship on both sides.
Well, and it creates the opportunity for there to be a windfall either to
Right.
the separate or to the community when some of the arguments were for and against it were what happens if the the employee is still required to work? Okay, the bonus is paid, but if you're not employed in February, you don't get the
receive
bonus.
it. Yes.
That's where we come in and we say, well, court, this should be awarded if, as, and when it's received, because it puts the risk on both. I mean,
Right.
if
Right.
the employee does something crazy and loses his job before February, everybody's
Nobody
lost
gets it,
out, but
right, 'cause
nobody
it's
gets it
gone.
because it's gone.
Yes. Yes.
But or if the company goes under or doesn't pay it, but
yes.
to the extent that when it is paid, if it compensates for that,
Yes.
that
They
when
should share it.
then they should share in it.
Mm-hmm. That's great. Well, and everybody wants money, so
I just think there's a lot of assets that some lawyers just don't consider, and they seem difficult to divide. But that shouldn't stop you from looking at every
Yeah.
bit of their somebody's compensation.
Yes, and advocating for that. And to your point, this will apply to judges and what they're doing, but in 85% of cases settle. So where it's really going to come into play is in the mediation rooms.
Mhm.
And the lawyers need to be keeping up with what's happening at the Court of Appeals, what's happening at the Supreme Court, what is the current law, because they need to be sure they're advocating and not unaware that, hey, their client has a right to some of those monies.
Well, and I'll tell you, when I went to law school, I've always been very intimidated by math. And so I told my one of my first year professors when he pulled out some formula on damages, I said, "Oh wait, I came to law school. I don't do math, But property division is a lot of math, and I would encourage lawyers if it's intimidating to you, this asset's out there, it still can be a very valuable asset. Find somebody that can help you do the formula or that can help explain it, because it is important to our clients to share in those forms of compensation. Stock options are another one, that I know it's not the easiest it's to see. You have to discover it. You have to look at how it's awarded, how
you have to dig in.
You have to dig in.
You have to get from the company often the explanation of those benefits.
Yes.
Because you can't trust that even the employee understands how it's coming about. And then to your point, there's plenty of great experts out there. It's not expensive to hire an expert to help you sort this. And they're financial experts. They do it all the time. They do a little chart, and you can bring that into mediation and say, oh, I have an expert. And it's not required if it's simple enough or you have enough experience that you understand it. But I mean, I've seen experts do it for $2,000. I mean, not a lot of money to make a great claim in mediation and not have the other side, poo-poo you about it.
Mm-hmm.
So this is really an opportunity and an encouragement for all the lawyers listening to dig into those benefits. And every company, corporation, business has a different benefit structure. They're not all the same, right? And when you get into government has its own, nonprofit has its own, retirement, pensions, etc. So don't feel like you're not a good lawyer if you don't understand all of it. Just hire someone to help you interpret it and to get to the bottom of it. And sometimes, especially with pensions, we have to have an actuarial come in and, we don't know how long someone's really going to live. And that's how pensions are really value is they're going to pay for a lifetime, but whose lifetime? So that could be tricky. But I'm so happy for you that you had such a great result. It was very exciting. I got to watch the argument. Very, very proud of you for your success.
Thank you.
And anybody would benefit by having you on their side.
Thank you.
And Jodi, your practice is in Wichita Falls, but you also handle the Dallas-Fort Worth area. Is that
I
true?
do. So my husband and I lived here for almost 20 years, and I came on as a partner at Duffee, or I came on as an associate and made my way, became a partner at Duffee+Eitzen. And when we moved to Wichita Falls, I came to you and to my other partner, Lisa, and said, "Oh, please, I want to stay working with you." I do. I love Duffee+Eitzen. I think we have fabulous attorneys, and I love working at this firm. And so what we've done over the years is
8 years now.
8
right?
years now. Well, 7, going on 8.
Mhm.
Is we've opened a Wichita Falls office. We're fully staffed there. So I work there, but I still have so many cases, and I keep up with the courts and the judges and everything that's going on in Dallas, so that when I get referrals, because I still do take a lot of cases from the Metroplex, Dallas, Denton, Collin, Fort Worth, so Tarrant, plus the appellate work. So
Mhm.
it's a nice balance.
Yes, yes. Well, I know you've even started doing a little mediation as a mediator in Wichita
I
Falls.
have. I've been learning from you, so that's exciting. Getting to have that opportunity and having the judges feel confident enough in me as a mediator to appoint me as a mediator in cases.
Thanks so much for taking time to be on the podcast
Oh,
today.
I'm so glad you had me. I enjoyed getting to visit with you, and thanks for letting me share about my success.
Yes. And thank you so much for watching. So, Supreme Court, it doesn't get better than that. And please keep watching. We will keep you apprised of any other big developments in the law. Thanks for watching.